Welcome in. If you're joining us for this custom deep dive, we know exactly who you are.
We really do.
You are the learner. You're that person who wants to gain a thorough, nuanced understanding of the world. And you appreciate looking at complex issues from multiple angles.
Right.
You live for those aha moments where the puzzle pieces finally snap together, but, you want to get there without drowning in dense academic information overload.
Exactly.
So, imagine this. You catch a company red-handed making a discriminatory decision, but the legal system tells you that they don't owe you a single dime in damages.
Seems completely contradictory, doesn't it?
It really does. It sounds completely broken. But that paradox is exactly what we are here to untangle today.
And it really is a fascinating paradox. We are looking at a very specific, highly strategic corner of employment law under Title VII of the Civil Rights Act of 1964.
Okay.
It's a concept known as mixed motive discrimination. And the reason this is so relevant to you as someone who studies how the world actually works is that human decisions are almost never simple.
I mean, that's just life, right?
Exactly. We rarely do things for just one pure reason. The reality of the modern workplace is incredibly messy.
So messy.
Right, and the legal system has had to build some remarkably complex frameworks to handle that reality. The law can't just throw its hands up when a situation isn't black and white.
Okay, let's unpack this, because it sounds like we're dealing with a lot of gray area here.
We absolutely are.
Let's start by laying out the core definition of what we even mean by mixed motive.
Sure.
We're talking about situations where there is proven intentional discrimination in an employment decision. Say, a firing or a failure to promote. But the employer turns around and claims that they had a completely valid legal reason to make that exact same decision anyway.
That's the crux of it. Picture a scenario where an employer clearly acts with discriminatory animus toward a protected class.
Like based on race or gender or religion.
Exactly. But simultaneously, that same employee was wildly underperforming, or maybe they explicitly broke a major, well-documented company policy.
Right.
So the employer's argument in court essentially becomes, yes, there was an illegitimate factor at play in our decision-making process, but we would have fired this person regardless because of this other entirely legitimate factor.
Let me jump in there, because this is where the stakes get incredibly real for anyone involved in a lawsuit like this. According to the specific provisions in the Civil Rights Act, specifically 42 U.S.C. Section 2000E5G2, if the employer can demonstrate what is called a same decision defense, they can completely avoid liability for money damages.
That's the paradox we mentioned earlier.
Right, and they only have to prove this by a preponderance of the evidence, which just means they have to convince a jury that it is 51% likely. Just more likely than not that they would have made the exact same decision even without the discriminatory factor.
And we really need to emphasize what avoiding those money damages actually means in practice.
Yeah, let's break that down.
If the employer successfully tips that scale and proves the same decision defense, the consequences for the employee who brought the lawsuit are severe. The law explicitly takes the biggest financial remedies off the table.
Which means what, exactly?
The plaintiff gets no order of reinstatement, which means they do not get their job back.
Wow.
Furthermore, they are prohibited from receiving any substitutes like back pay for the wages they already lost or front pay for the wages they will lose in the future.
Wait, hold on. Let me make sure I'm hearing this right.
Go ahead.
If I'm the plaintiff and I just proved to a court that my employer was intentionally discriminating against me, but they managed to prove they would have fired me anyway.
Because of the separate, legitimate reason.
Right, because I was late a bunch or whatever. I don't get my job back, and I don't get a single dollar of my lost wages. What exactly do I get? Doesn't that just give businesses a free pass to harbor prejudice as long as they can find a typo on my resume?
I know. It's a very limited set of remedies, which is why it feels so jarring. If the same decision defense is proven, the plaintiff is essentially only entitled to declaratory and injunctive relief alongside their attorney's fees and court costs.
Okay, let's define those for the listener. Declaratory relief basically means the court issues a formal statement, a declaration saying, yes, your civil rights were violated.
Correct.
And injunctive relief means the court can order the employer to stop the discriminatory behavior going forward.
Exactly.
Plus, they have to pay your lawyers. But the employee themselves walks away without a financial payout for their own economic suffering.
It is a profound compromise by the legal system. It's designed to acknowledge the wrongdoing and force the company to correct its behavior. Hence the injunction and the attorney's fees, which punish the employer and incentivize lawyers to actually take these civil rights cases.
Because without attorney's fees, no lawyer would take a case where the client isn't getting a payout.
Exactly. But at the same time, the law refuses to grant a financial windfall to an employee who legitimately deserved to be fired for other reasons. It's addressing a situation where both sides are essentially pointing to a truth.
Which brings us to how we actually got to this compromise. We had to travel back to 1989 to a landmark Supreme Court case that absolutely shaped this landscape.
Yeah.
We were talking about Price Waterhouse v. Hopkins.
Volume 490, U.S. Reports, page 228, for those keeping track.
Right. This is the case that really blew the doors open on how these messy dual motive situations are handled in court.
What's fascinating here is the sheer human complexity of the facts in the Price Waterhouse case.
The facts are wild.
They really are. Ann Hopkins was a senior manager at the accounting firm Price Waterhouse. By all objective metrics, she was a stellar performer. She secured a massive multi-million-dollar contract for the firm. She billed more hours than almost any other candidate up for partnership that year.
She was a star.
But when she was proposed for partnership, she was put on hold and eventually denied.
And the reasons she was denied are where the mixed motives come into play. On one hand, you had undeniable evidence of gender discrimination. The partners evaluating her literally submitted written comments saying she was macho, that she overcompensated for being a woman.
Which is just blatant.
Oh, it gets worse. Incredibly, one partner advised her that to improve her chances for partnership, she needed to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry.
It is staggering to hear those comments read aloud today.
Yeah.
That is the illegitimate discriminatory motive staring you right in the face. But on the other hand, Hopkins also had well-documented interpersonal issues.
Right, the other side of the coin.
Staff members found her abrasive, overly aggressive, and difficult to work with. She routinely clashed with staff. So the firm argued, we didn't deny her partnership because she's a woman. We denied it because she lacked the interpersonal skills required of a partner.
It's the ultimate collision of right and wrong on both sides. So how did the Supreme Court untangle that? Because they have these two competing truths sitting right in front of them.
The Supreme Court handed down a pivotal ruling. They decided that a plaintiff does not need to prove that discrimination was the sole reason for the employment decision.
Which is huge.
It's a game changer. If the plaintiff can prove that discrimination was a motivating factor, even if other legitimate factors existed, the burden then shifts to the employer. The employer then has to prove by a preponderance of the evidence that they would have made the exact same decision even if they hadn't considered the discriminatory factor.
So if we look at the Ann Hopkins case, she didn't have to prove that her interpersonal skills were perfect. She didn't have to prove everyone loved working with her.
Right.
She just had to prove that the blatant gender stereotyping played a role in the decision. Once she did that, the firm had to prove they would have denied her partnership based only on her abrasiveness. This ruling was massive because it finally recognized that discrimination is rarely the only thing sitting at the table when a hiring or firing decision is made.
Precisely. And it also established that plaintiffs don't necessarily need a smoking gun to win these cases. Before this, many courts struggled with how to handle cases where employers were hiding behind legitimate reasons, but illegitimate reasons were clearly lurking in the background.
So what does this all mean for a lawyer who is sitting at their desk today, looking at a stack of evidence, trying to figure out how to classify a case? How do they know what kind of legal battle they're actually walking into?
That takes us into the intricate mechanics of how these trials are actually fought. To understand the modern landscape, we look to a 2002 case from the Third Circuit Court of Appeals called Fickett v. Aetna, Inc.
Okay.
This case clearly delineated the traditional dividing line between what courts call a true mixed motive case and what they call a pretext case. And that dividing line is all about the type of evidence the employee brings to the table.
Let's break down those two paths for the listener.
The first path is the direct evidence path. If the plaintiff actually has direct evidence showing that the employer's decision was motivated by animus toward a protected class, like the written comments in the Price Waterhouse case telling her to wear more makeup, then the court classifies it as a mixed motive case.
Got it.
When that happens, the judge gives the jury a very specific instruction on how to weigh those competing motives using the framework we just discussed.
But let's be real. Direct evidence is incredibly rare.
Very rare.
Employers today usually don't write down that they want someone to go to charm school or put their prejudices in a memo. So what happens when the employee doesn't have that smoking gun? What if they only have circumstantial puzzle pieces.
That takes us to the second path, the circumstantial evidence path. If the evidence of discrimination is only indirect, the case is traditionally classified as a pretext case.
A pretext case?
Right. And in a pretext case, the courts don't use the mixed motive instructions. Instead, they use a highly choreographed legal mechanism called the McDonnell-Douglas burden-shifting framework.
The McDonnell-Douglas burden-shifting framework.
Yeah.
That sounds like a complex legal chess maneuver.
It really is.
Let's actually walk through what that looks like in action, because it's crucial for understanding how these cases are fought. It's essentially a three-step dance.
Right. It is exactly a three-step dance. Step 1. The employee has to establish a basic, surface-level case of discrimination. They have to show they are in a protected class, they were qualified for the job, they were fired or suffered an adverse action, and the circumstances look suspicious.
It's a relatively low bar.
Very low bar, just enough to get the court's attention.
Okay, so then the ball is in the employer's court. Step 2.
Step 2. The burden shifts to the employer. The employer now has to articulate a legitimate, non-discriminatory reason for the firing. They don't have to prove it was the actual reason. They just have to state a valid legal reason.
For example, we fired him because he was late 3 times last month.
Exactly.
Which brings us to the final, hardest step. Step 3. The ball goes back to the employee.
Right. In step 3, the employee has to prove that the employer's stated reason is a pretext, meaning it's a cover-up.
Hence the name, pretext case.
Yes. The employee has to show that they weren't actually fired for being late, but that the lateness is just a convenient excuse to hide the real discriminatory reason.
So in a pretext case, it's an all-or-nothing battle. You are arguing that the employer's legitimate reason is completely fake, whereas in a mixed motive case, you are admitting the legitimate reason might be real, but the discriminatory reason was also real.
Exactly. You're trying to say that the fake reason was just a smokescreen. This raises an important question, though, because the Supreme Court threw a massive wrench into this clean division in 2003 with a case called Desert Palace Inc. v. Costa.
Another landmark case.
Oh, absolutely. The court recognized exactly what you just pointed out. Direct evidence is almost impossible to find. So in Desert Palace, the Supreme Court ruled that a plaintiff does not need direct evidence to get a mixed motive jury instruction.
Wait.
Yes. They can use circumstantial evidence to prove that discrimination was a motivating factor.
Wow. So Desert Palace essentially blurred the lines. It allowed employees to use the puzzle pieces, the circumstantial evidence, not just to prove a cover-up in a pretext case, but to argue that it was a mixed motive situation.
It absolutely did.
That must have sent shockwaves through the strategies of employment lawyers everywhere.
It fundamentally changed how employers have to defend themselves, because suddenly, circumstantial evidence became much more dangerous. They couldn't just brush off indirect evidence anymore.
Here's where it gets really interesting, because all of these definitions, the evidence paths, and the Supreme Court rulings lead to what is essentially a high-stakes psychological chess match between the employer and the employee.
It really is a game of chess.
We have some incredible analysis on this from a 2005 article published in the St. Mary's Law Journal. It's titled Much Ado About Nothing, written by Matthew Scott and Russell Chapman. They break down the strategic game theory of these laws brilliantly.
The Scott and Chapman article is fantastic because it strips away the legalese and looks at the strategic trade-offs. It shows how the law attempts to balance the scales of justice based entirely on the defensive posture the employer chooses to take.
Right.
They lay out 2 contrasting scenarios that every employment lawyer has to agonizingly weigh before walking into the courtroom.
Let's set up the board for these 2 scenarios. Scenario A is the traditional pretext case, right under 42 U.S.C. Section 2000E2A. In this scenario, the employer completely disavows any illegal motive whatsoever.
Total denial.
They stand firm, they dig their heels in, and they profess that they had only a non-discriminatory motive for firing the employee. We fired them for being late, period. Nothing else played a role.
Right. The employer in scenario A is taking a hard-line stance of absolute innocence regarding discrimination. Now, when the employer does this, it forces the plaintiff into a very difficult position.
Because of the burden of proof.
Exactly. The plaintiff now has to prove that the challenge employment action was taken because of their race, gender, religion, etc. The legal standard is because of, which is an incredibly high bar.
It's all or nothing.
Right. You essentially have to prove that if the discrimination hadn't existed, the firing wouldn't have happened.
It's a massive burden for the employee to carry. But, and this is the gamble for the employer, if the employee is successful in proving that the action was taken because of that discrimination, they hit the jackpot.
They certainly do.
As Scott and Chapman point out, The successful plaintiff in Scenario A is entitled to the full panoply of damages: reinstatement, back pay, front pay, emotional distress, the works. The employer took a hard line, they lost the gamble, and now they pay the maximum financial penalty.
Exactly. It's a high-risk, high-reward strategy for both sides. Now let's look at Scenario B, the mixed motive case under 42 U.S.C. Section 2000 E2 meter.
The other side of the chessboard.
Precisely. In this scenario, the employer takes a completely different posture. The employer is somewhat contrite. They either openly admit to a partially discriminatory reason, or they look at the evidence the employee has gathered and realize, okay, a jury is going to believe that bias played a role here.
They see the writing on the wall.
But, crucially, while they concede the improper motive, they deploy the same decision defense. They claim they still would have taken the same action anyway because the employee was terrible at their job.
So they're walking into court and saying, yes, part of our reasoning was discriminatory and we shouldn't have done that, but we still would have fired them because they stole from the cash register.
Right.
This is where the concept of quid pro quo comes into play. A legal this for that.
And that is the perfect term for it. As the authors of the article emphasize, no jury takes an admitted improper motive lightly. It is a terrifying thing for a corporate lawyer to advise their client to admit to discriminatory reasoning.
I can imagine. You're basically handing the plaintiff a massive PR victory and angering the jury right out of the gate.
However, the legal quid pro quo makes it incredibly tempting. By admitting it and successfully proving the legitimate reason, the employer's financial risk plummets.
Because of those cap damages we talked about.
Exactly. As we discussed at the very beginning, their liability is reduced to declaratory relief, injunctions, and attorney's fees. They completely eliminate the risk of massive back pay or front pay awards.
They essentially put a hard cap on their financial bleeding. But what is the quid pro quo for the plaintiff? Why would an employee ever agree to fight a mixed motive battle if the payout is so small?
In exchange for the employer getting that reduced financial risk, the plaintiff gets the benefit of a much lower standard of liability. Remember, in Scenario A, the plaintiff had to prove the firing happened because of the discrimination.
The all or nothing standard.
Right. In Scenario B, the mixed motive case, the plaintiff only has to prove that the discrimination was a motivating factor. They don't have to prove it was the sole cause or even the main cause. They just have to prove it was in the room and played a part in the decision.
It is an absolute seesaw of legal strategy. You are directly balancing the burden of proof against financial damages. If you make it easier to prove liability, you lower the damages. If you demand maximum damages, you have to meet the hardest burden of proof.
That's the architecture of the law.
It's brilliant, but it's also incredibly cynical when you think about it from a human perspective.
If we connect this to the bigger picture, this deep dive perfectly illustrates why the law can't afford to be purely idealistic. The law isn't always a blunt instrument of absolute right and wrong.
No, it really isn't.
In these mixed motive cases, the legal system is acknowledging that two completely contradictory truths can exist at the exact same time. An employer can harbor deeply illegal prejudice, and an employee can legitimately deserve to be terminated for their performance.
It's the grayest of gray areas.
Exactly. The law has to look at both of those truths, weigh them on a calibrated scale, and find a way to assign liability that reflects that messy reality. It's designed to discourage discrimination by slapping the employer with attorney's fees and injunctions without forcing businesses to retain or provide windfall payouts to employees they genuinely had a right to fire.
We've covered incredible ground today. We moved from the foundational definitions of the same decision defense, explored the human drama of Pricewaterhouse v. Hopkins, untangled the complex burden-shifting frameworks, and finally analyzed the high-stakes game theory of the courtroom.
We really unpacked a lot.
But before we wrap up, we want to leave you with one final provocative thought to mull over as you go about your day. Take everything we've just discussed about the strategic quid pro quo and ask yourself this. If the legal system intentionally allows an employer to escape paying financial damages to an employee by proving they would have fired them anyway, does that setup successfully protect businesses from unwarranted payouts? Or does it inadvertently create a discount for admitting to prejudice?
It's a profound question that really challenges how we define justice in a flawed world.
It really does. Thank you so much for joining us on this deep dive. Keep feeding that natural curiosity of yours. Keep looking for those multiple perspectives. And remember that no matter how complex the topic, there is always more beneath the surface to explore. We will catch you on the next one.